So perfect
She was
the way it's
with me
played.
throughout this whole process. So I think for better or worse, she was, experienced the whole thing with me. So big, beautiful summer movie, but it's actually like a pretty intimate movie. So we never thought, like our eyeballs were not that big to think that we could, put one of her songs in the movie. And it had to be. And there was a moment in the movie that it was missing this like emotional gravitas. And like, as soon as we put that song in, it was just like, I was like, that's the spot. I mean,
Hello guys, welcome back to my channel Reality Exposed TV. Let's get back into it. There was a bomb that was dropped yesterday. Baldwin's lawyers, Bryan Freedman, wrote a letter to the judge, and he informed the judge that a subpoena that they had sent out to a law firm that represents Taylor Swift was not overbroad and asking irrelevant information. They were answering a letter that had been placed before the court by Lively's lawyers informing them of the imminent issue that was occurring in the D.C. District Court. Vendel had made a motion to quash and was essentially saying, "This is too broad. The time periods don't work. We don't have any information to provide. You can obtain this from them. We are not a party to this. Just because we represent Taylor Swift doesn't mean that we have information." And they were attempting to say they didn't truly know what they were looking for. And I don't know if they ever even got together and discussed it. And so we saw the Blake team jump right in and file an intervention and allege, "Listen, we're intervening in this motion, in this subpoena. You don't need these records. These records are irrelevant. It would be invading our privacy. It has nothing to do with this, and they're just doing this for improper motives." Okay, and after they did that, so far nothing has been submitted to a judge by Wayfair in the D.C. court, and that's because Bryan Freedman informed the judge in the New York Southern District Court, Judge Lehman, that he was taking the time to meet and confer with the attorneys of Vendel regarding this subpoena. He informed the judge the following: "The WFR parties expect that Vendel's motion to quash will shortly be made moot by the fact that their attorney and Vendel are meeting in good faith. However, the Lively party's contention that the subpoena requests irrelevant information is erroneous." So their letter to the judge was essentially like, "Listen, we've contacted Vendel currently. We're meeting and discussing what it is that we're after, and we're working out what we're going to do with this information that we're looking for. And the information they're looking for is supposedly related to potential witness tampering and spoliation of evidence." All right. And they're claiming that Lively asked Taylor Swift to erase their text messages. They're also claiming that Michael Gotottle of Wilkie Farr, attorney to their defendants, phoned up Venable attorney representing Miss Swift and instructed Miss Swift to issue a statement in support of Miss Lively, and threatened that if Miss Swift did not comply, her private text messages or of a personal nature in her possession would be leaked. And the party's attorneys are also advised and think that one of Miss Swift's representatives spoke to the offensive and seemingly extortionate threats, at least in one written statement sent to Mr. Gotottle, and that's what they want. And they explained that, "Hey, we're going to collaborate with them, and if we can determine how to get this accomplished, we won't even have to be concerned with the subpoena. However, if these negotiations do not pan out, we'll either resist the motion to quash or we'll pull the current subpoena in favor of one that's a whole lot more limited and only seeking communications for that particular region regarding this possible witness tampering and the potential spoliation of evidence." So that obviously created a furor. I mean, what wouldn't? It's a giant narrative, isn't it? It's a giant piece of news. But for the record, Freedman is affirming this to a judge on a sworn statement, on a motion where he has his name on it, and it's under penalty of perjury. So there's no motivation for him to be lying here, and he is doing discovery, which is part of this process, and he was answering a letter that they had written stating that the information was irrelevant. Okay, clearly that annoyed Blake's lawyers, and now they are angry, and they are asking for a motion to strike, and they're arguing that, first of all, this never even occurred. They're lying, and you have to strike this from the record because it's laundering of defamatory claims. And I thought that part was just so cute, because we all know who they're accusing of laundering evidence, right? And something I've noticed about Blake's camp is that they've made a lot of claims about Baldoni, right? And they have alleged a great deal of things with no evidence, correct? And it is fine for them to do that. But if someone else does the same thing, then that is defamation. So her lawyer indicated that they were respectfully requesting to strike the letter that signed by Bryan Freedman submitted earlier today. The letter was not submitted with any evidentiary proof of any type, much less anything under oath. Incorrectly accuses Miss Lively and her attorney of witness tampering and spoliation of evidence upon an unidentified anonymous source. She asks that the court strike the Freedman letter under its inherent power to manage and to strike from its docket material, which is abusive or otherwise improper under the circumstances. So because this went public and he filed it in court, they're asking him to remove it from the record because they're labeling it as irrelevant and abusive. It should not be required to reply to anonymously sourced, unsubstantiated claims speciously made without proof. That's fascinating. It is worth noting for the record, however, that every one of the accusations in the Freedman letter is absolutely and provably untrue. As a matter of law, the Freedman letter is not proper. It does not request any type of relief, is not pertinent to any motion that is actually pending before the court, and has no legitimate purpose. It is not helpful to the court in any way. Miss Lively's letter was a complaint to which the Freedman responds for courtesy purposes only to advise the court of a motion to quash proceeding that Venal initiated in a different federal court in order to maintain their own right to object to the third-party subpoena. But she did not request the court to do anything, and her letter was not worthy of or deserving any response from Mr. Freedman, much less one that attempts to create a conspiracy theory in order to get opposing counsel's communications through a third party. Fine. Anything that gets put into this case, their default is to label everything a conspiracy theory. And they're denying it outright and saying, listen, we didn't do this, it's completely false. And also, everything that he included in there is immaterial because he didn't even have to reply to the letter to the court. In court, even if it's not a motion, and if a counsel submits a letter to the judge and says, listen, judge, this is going on in a different district, this is what we're doing, then the other side can absolutely respond to the letter to the judge if there is a discrepancy in the information that the counsel for one party is presenting to this judge. And so my perception of his answer was to put the record straight, as much as I'm informing you that this is what we're looking for because they've indicated that it's not relevant. So it's like they'd gone to the court, made their declaration, and just simply assumed there would be no reaction. I don't think on that premise that what he did was immoral. But of course it's something that they would not want known, or it's something that is not in their favor, and it's implying crime, essentially, and it's placing her lawyers at the center of some kind of criminal conspiracy to obstruct a witness. And of course they will not be happy about that. And I said yesterday that's a very serious charge to level. The seeming purpose of the Freedman letter is to sanitize scandalous and defamatory charges against Miss Lively and opposing counsel into the public eye through abuse of the court's docket and evasion of the order, mandating attorneys in this case to obey Rule 3.6 of the New York Rules of Professional Conduct. In minutes of Freedman's letter being filed on the court docket at 1:50, media companies started publishing news about the Freedman letter, including one that was an online 40-plus paragraph article at 1:55 stating as fact that Miss Lively threatened to reveal Taylor Swift's private text unless she publicly endorsed her in Justin Baldoni's feud, and they connect this to an article by the Daily Mail's Ruth Stiles. So the implication here is that Bryan Freedman tipped off Ruth Stiles, and somehow Ruth Stiles wasn't monitoring the docket, and she somehow wrote a 40-page article within 5 minutes. And so she must have received this from him. That reads a heck of a lot like what Wayfair has charged they did to the New York Times. We will read that article and find out what it really states in a minute. But that claimed as fact that Miss Lively threatened to publish Taylor Swift's private text unless she came out publicly supporting her in Justin's feud. In a February 3rd hearing, this court clarified to the parties that it would step in if it transpires that this winds up being litigated within the press in a fashion that would taint the chance of the parties at a fair trial. The court ought to immediately strike the Freedman letter from the docket to keep from producing precisely the outcome it foreshadowed at the first hearing. So what they're telling the judge is, this information is very damning to our clients, and it could absolutely impact Blake's ability to have a fair trial. I think the bigger implication here, yes, if it's not true, sure, but if it's true, it does make it hard for her to have a fair trial, because the case could get thrown out. She could get sanctions. There may be criminal charges. There may be evidence that's discarded. In some extreme situations, if there is spoliation and intimidation of witnesses on a civil end, there can be negative instructions to the jury that informs them like, listen, this individual did this and she was discovered that she did this and this evidence was erased. And any time evidence is deleted, it's under the assumption that you would not delete evidence if it was not adverse to the party that they're deleting, that who's deleting it. So that could be something that happens as well. There could be criminal charges, there could be contempt of court, there could be fines, sanctions, attorneys' fees awarded. So Freedman's letter's already kind of suggesting that if this is true, they can go after all of that against them. And so obviously their stance is that it's untrue, and we're going to pursue sanctions against them. And it states whether or not to grant a motion to strike is committed to the trial court's sound discretion. Courts possess the inherent power to regulate their docket and delete material that is abusive or otherwise inappropriate given the context. And it asserts that such power comes from a court's power to administer its own affairs, so to secure the orderly, expeditious resolutions of cases. Miss Lively respectfully asks the court to exercise its inherent power to manage its own docket and strike the Freedman letter as unnecessary, improper, and abusive. She does not waive her right to proceed with sanctions pursuant to the Rule 11 of the Federal Rules of Civil Procedure in relation to the Freedman letter at a future appropriate time. You know how they tell you if you call something to your attention, there's like the Streisand effect, and so it makes the scenario even greater. And that is sort of what's occurring here because the motion to strike will provide Wayfair with a chance to respond. And my goodness, did Mr. Freedman respond large. Some of the arguments they had made there were that everything was not under oath, everything was done through anonymous sources, and one can't believe anything here and it's being done simply for abusive purposes. Well, he addressed a few of their issues. And this is what he informed the judge. We write pursuant to a letter motion to strike by the plaintiff and consolidated defendant Blake Lively. The motion requests the court to invalidate my May 14, 2025 letter. The May 14th letter was filed in reply to Miss Lively and merged defendant Ryan Reynolds's revised letter of May 13th. The May 13th letter appearing to notify the court of their motion to be allowed to intervene in an action pending in a different federal court concerning a motion of Venable LLP to quash a subpoena issued to them by my office. The theory of the motion is that I intentionally and brazenly misrepresented to the court and that the facts stated in the May 14th letter are false and without foundation. That is not the case. Included with this is an exhibit signed under penalty of perjury setting forth the factual basis of the statement set forth in my May 14th letter. Ooh, so he's raising the stakes. He's going to put himself on record, and this is, if he's a liar, he can get prosecuted for perjury. Okay. So interestingly, the motion is signed by not Michael Gotottle, whose actions led my office to issue a subpoena to Venable, but by a different attorney from a different firm representing the Lively defendants. The motion also criticizes the May 14th letter for having been filed without any form of evidentiary support, let alone anything under oath. The opposition provides the sworn affidavit, which Lively claims the May 14th letter was lacking. Last but significantly, the motion asserts that facts presented in the May 14th letter are demonstrably and unequivocally false, but it's not backed up by any sworn affidavit to that point, let alone from Michael Gotottle. You recognize that's fascinating. The letter was signed by Ezra Hudson, not by Michael, so Michael didn't proceed under oath. Michael didn't swear under the threat of perjury. Perhaps he will now, but it certainly was signed by Ezra and submitted by Ezra Hudson, an entirely different law firm. The motion also argues that the May 14th letter was improper in that it does not seek proper purpose. Naturally, the same could be said regarding the defendants of Lively's May 13th letter, which Miss Lively alleges she had sent as a courtesy, and in which she did not request the court to do anything. In the May 13th letter, The Lively defendants assert that the subpoena issued on Venable demands the Lively defendants' attorney communications, including Mr. Gotottle's, with no reason why they might be relevant to a party's claim or defenses in this case. In light of the fact that Miss Lively herself acknowledges in the May 13th letter that she did not request the court to do anything in such letter, nor could she, inasmuch as the motion to quash the subpoena to Venable is pending before another court and is beyond the jurisdiction of the court, it is clear the May 13th letter was submitted to the court in order to tarnish the Wayfair parties and their attorneys. A reply was warranted. The letter of May 13th asserts in open court that my office subpoenaed Venable for an improper purpose instead of seeking relevant documents. In response, we forwarded the May 14th letter to set the record straight. The motion must be denied. So that's interesting, he is highlighting the fact that she did not actually have to send the letter to inform them of the motion to quash matter that is ongoing in a different district in a different court where the judge has no authority. And he's claiming that the sole reason she did that is so it would appear his lawyers were engaging in improper abuse of procedure and issuing subpoenas unreasonably, abuse of the discovery process. So already she was taking shots at them and accusing them of misconduct. And so he's saying, I had to respond to that because that's not what we were doing. So then he ups the ante, you guys, and this is where it gets a little bit wild. He tells the court in a sworn affidavit the following. So that's interesting, he is indicating she did not actually have to send the letter to inform them of the motion to quash issue that is happening in another district in another court where the judge has no authority, and he's claiming that she only did it in order to pretend like his lawyers had engaged in improper abuse of procedure and issuing subpoenas without reason, which is abuse of the discovery process, so she was already throwing shots at them and accusing them of misconduct. And so he's saying, I had to reply to that because that's not what we were doing. So then he raises the stakes, you guys, and this is where it gets a little bit crazy. He tells the court in a sworn affidavit the following. He introduces them to who he's a partner of and all of that. So he presents this in opposition to the May 14th motion to strike filed by Blake Lively in my May 14th letter explaining the grounds for the Wayfair party's subpoena of Venable LLP. So be careful what you wish for, I guess, is what I'm going to begin this out with. But on February 14th, I got a voicemail from someone who was very closely associated with Taylor Swift that I then called back the same day. Because of respect for the person in question, I am not naming them at present, but if the court tells me otherwise, I will follow the order of the court. So he's guarding this close witness to Taylor. So a friend of Taylor's came out, is what he's saying, and very closely related. Could it be Travis Kelce? Could it be Tree Payne? Could it be one of her managers? I don't know. But on the February 14th telephone call lasting about an hour, the speaker informed me that they had heard that Douglas Baldridge, attorney for Taylor Swift and partner at Venable LLP, had been called by phone by Michael Gottottle, attorney for Blake Lively and Ryan Reynolds, in which Mr. Gottottle asked on behalf of Miss Lively that Taylor Swift issue a social media message in Miss Lively's favor due to her failure to attend the Super Bowl that year, and that if Miss Swift did not do so, Miss Lively would publish 10 years of personal texts with Miss Swift. The person also informed me that they had been told Mr. Baldridge had charged Mr. Gottottle with extortion and hung up. On the same February 14th call, the person informed me that they had been told 4 or 5 months previously Miss Lively had asked Miss Swift to delete her text messages with Miss Lively. I was referred to this person by a common friend who told me that the person would like to speak with me. We have had a number of phone calls since February 14th. On a subsequent call with the same person, the person explained that Mr. Baldridge had sent a written message to Mr. Gottottle regarding the phone call. My office subpoenaed Venable LLP for the sole reason of obtaining the above-mentioned written communications. I affirm under penalty of perjury under 28 U.S.C. 1746. Okay, so it is February 14th, and they're asking she issue a statement because Taylor was out at the Super Bowl but Blake did not attend. And Blake's team was in the public saying that she missed it because of the controversy surrounding the case. And Taylor's camp was saying in the public that she wasn't invited and that Taylor was distancing herself from Blake because she felt used by being referred to as a dragon and exploited. And so if Taylor's public remarks and her leaks are claiming Taylor did not invite her because Blake is wielding her as a weapon in this suit, Lively insisting that she go on social media to be supportive of Lively would be a very clear indication that Swift is going to side with her in the court case, attempting to then get the public image that there's a split between the two of them over this lawsuit suppressed in the press. So if that's true, that's fairly damning. And if they did call it extortion in real time, that's fairly damning. And it's similar to what happened with Justin Balan. Right when he was informed, it sent out this message, or else the gloves would come off and I will expose you. Now, to be fair, 10 years of text messages haven't been released, right? But they might be through this lawsuit, and that might 100% embarrass Taylor. If her lawyers stepped in right away and said something and threatened back with like, "We'll sue you if you do that," it might have made her stop whoever is telling her this is someone close to Taylor and it's immediately after the Super Bowl. Maybe Travis, maybe someone from the group, but I have to presume here that Taylor isn't going to inform very many people of what's going on with her attorneys, okay? Because whoever she's telling this to, waiving attorney-client privilege, okay, and they're not married, so that would be spousal privilege isn't available, but whoever she's telling this to, she is close enough to that she trusts them. And if that person then is going to Freedman, the question is, here may be that Taylor wanted this individual to step forward for her too. Freedman to inform them of what was going on so that Taylor wouldn't have to speak about it publicly, and she didn't need to get involved in it, but she could have someone close to herself get involved on her behalf if that sounds right. And then the same individual also is informed that Swift informed them clearly that she had asked Swift delete the texts with Lively, so they reach out to him, they're connected by a mutual friend, and he'd be happy to reveal who the source is if the court tells him to reveal. So he's essentially informing the court they're not anonymous, they are a very real person. They have very intimate information that they possess about Taylor's legal troubles that are not public about this case. And if you tell me to mention their name, I will. But I'm guarding them presently due to the find and due to all of the intimidation that these individuals are already getting anyway. Right, so the same individual is the one that's relaying these matters to them, and they're extremely closely linked to Taylor Swift, so it's somebody in Taylor's camp. You do with it what you wish with that. But I'd bet that this is what occurred because he's under the penalty of perjury. He's making these statements under the penalty of perjury. He is not swearing that the information is true. He is swearing, this is what the person said to me, and I'm swearing to you, this is what I was told by this person. And it's God, it sounds so much like you better come out and stand up for me and defend me and get this bad press off of me. You guys, I apologize, but if you with Taylor Swift, who has way more followers, is a bona fide superstar and is in a stratosphere in her fame that exceeds Ryan Reynolds times a billion you have with the wrong one, and Taylor is going to defend herself. She's going to defend her friends, she's going to defend her business, and she's going to defend her image before she ever or bows to such a behavior. And if this is true, it would account for why she has not said anything publicly, because it's been going on since before the lawsuit occurred. It would also account for why Taylor had been keeping her distance, and they stated that 4 or 5 months prior to this occurring, that Lively asked her to delete her text messages with Lively. That Swift do so. So 4 or 5 months is October. October was the last that Taylor Swift saw Blake Lively and who she was with Travis Kelce. They had dinner out, Ryan and Blake dined with Travis and Taylor. And that's the last that they've ever been seen publicly together. So it could be Travis, but whoever this individual is has the type of information you'd only disclose to someone that you actually trusted, like your boyfriend or your mom or your manager or your publicist. So what do you think about this response? Do you think that Bryan, now that he's gone on record, and how do you think Blake's team is going to respond? I mean, he has a sworn affidavit with a notary here stating that this is under the penalty of perjury. That's how serious he is here, and Goddell hasn't done that. So you tell me what you think. Who do you think, and do you think that whomever stepped up for Taylor is there to defend her and Lee, or are they lying? Because to me, if this was Travis doing this is a boyfriend that's out to defend his girl, and that's a good man if it's Travis. That's what I'm saying. So what do you think? Let me know in the comments below. Let me know what your opinion is about the whole thing. And don't forget to give this video a thumbs up. Be sure to share this video with your friends and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.